Hello, everybody. It's great to be back in Dundee after my recent trip to West Africa. And welcome to everybody joining, those of you joining live this afternoon, and those of you who are watching the recording. So today we've got a great session with Kelsey and the team looking at oral skills and presentations. And Kelsey has told me next week an even bigger one when you're looking at EGLE issues to help you prepare for the internals moot. Now, one really important piece of housekeeping that Libby has reminded me of. We do hope to start the individual school-specific workshops next week. So we really need all of the schools to respond and to give us times as to when you'll be available to have a session with the great team here at Dundee Law School. So I'm going to pass now to Kelsey to kick things off.
Great. Does Libby have any housekeeping before?
No, just the usual. Thank you, Kelsey. Just the usual, that if you have questions, please feel free to raise a hand. We can certainly unmute you so you can ask your question in person of the team. And I know the team like to be interrupted with questions. It keeps the discussion going. So it's great if you can do that. But if you don't feel comfortable doing that, then you can use the Q&A function. Apart from that, please don't share any personal details in the chat function just because we're recording this session. But back to you, Kelsey.
So as Peter said, today's presentation and lecture is about oral skills and the presentation within your moot. Now, this is really important, as we've talked about before, and very easy to pick up marks just to make sure that you're, sorry, struggling to share my screen. Just making sure that you present yourself confidently and that you don't act rude or too casual, and just make sure your speech is very professional. Okay, so the learning aims is to be able to present yourself confidently and clearly and understand how to introduce authorities in your submission. This is really important because you want to be able to highlight to the judge where you're bringing in a legal authority instead of just your own opinion. To be able to reply to judicial intervention, the judge is going to stop you during your speech and you will need to respond to them, and you need to either know the answer or know how to say politely that you're not sure about what the answer is. We're also going to briefly touch on identifying points for rebuttal. This is not going to take up a large part of your submission, but there should be, and we expect there to be, a little bit of rebuttal in there, and we'll speak later about what that means. And to be able to use your time efficiently. We have given you 7 minutes to which to deliver your submission, so it's important that you kind of stick as closely to those 7 minutes as you can. You don't want your speech to be 3 minutes, and we will stop you if you go over 7 minutes.
So definitely just to chip in on that, some of the moots that I've done recently, when the mooters have actually stopped after 3 minutes, they just can't have said enough to be able to get a really good score. So it's really important to make sure that you use your full time. But also, as Kelsey has said, it's really important not to, well, you can't run over it, we'll just stop you. So you don't want to leave lots and lots of great stuff right in, or indeed to rush to think, oh my goodness, I've got to get all this stuff sort of packed in, and then your delivery really suffers. Can I just, before you continue, Kelsey, can I just ask one little question? We have a great video showing good practice, bad practice. Are you going to show that today, or is that already been circulated to everybody?
We've sent the link, I think, in the last lecture and the lecture before, and it has been sent in the WhatsApp group chat. So hopefully,
yeah. So if you've not watched that, it's a fantastic video of good practice, bad practice, and yeah, it's from some previous colleagues who were involved in the mooting training, and they, including Kelsey, and it was great fun making that. So definitely have a look out for that. It's a great indicator of what to do and indeed what not to do. Kelsey?
Yeah. We've also shared the mouse and the salad as well, Peter. So that also has a very good section. That's in 3 episodes, and the second episode and the third episode are particularly important in
acting in it as well.
Excellent acting, Oscar performance worthy.
Okay, so yeah, those videos and kind of those resources are really helpful because the presentation in a moot is very different from how you might think kind of a debate would be. We're not looking to be kind of argumentative, and we're looking to be very professional and level-headed and just deliver your presentation as calmly and not aggressively to the judge, if that makes sense. So just a quick recap on mooting. If we remember, it's a competitive mock court appeal case, and the teams will be presenting submissions for each party, so either the appellant or respondent, to persuade the judge that their interpretation of the law is correct. Now, you want to persuade the judge, but you don't want to start arguing with the judge, and we'll kind of touch on that in judicial intervention as well. If the judge is saying something you don't agree with, you have to kind of politely try to not disagree with them, but still put forward your argument. Each moot has 2 teams competing against one another, and the winner is decided both on advocacy skills and legal knowledge. We spoke about legal knowledge last week, so this presentation is really going to focus on those advocacy skills. And during their arguments, students will be asked questions by the judge. So we kind of spoke last week as well about how it's marked, and there's different ones. So I've just highlighted kind of the ones or the criteria that the judges will be looking at in terms of oral advocacy and presentation skills. So we're looking at oral presentation. Are you coming across clearly? Are you speaking at a good pace? Are you speaking at a good volume? All those types of things. We're also going to think about relevance of authorities. So are you able to articulate your authorities well and why they apply to the case? Looking at your speaking skills and use of etiquette. So saying things like naming the judge correctly, my lord, your ladyship, saying it is respectfully submitted, my learned friends across the bar, all those type of etiquette skills. We're also going to look at response to questioning, effectiveness of rebuttals, and use of time. So firstly, just looking at presentation skills, we know and we expect that nerves are normal and that people are going to be nervous, but like it says in the slide, it comes down to what you do with them. So I think it's best for people to always record themselves before they actually do their moot, to be able to check how fast they're speaking, whether their kind of hands shake, which is very common, or whether they find themselves picking up pace. So if you're able to record yourself or get a friend to watch you as you deliver your presentation, you'll be able to identify kind of how your nerves show themselves and then be able to mitigate that when you actually give your presentation in the competition. So if you find that your hands often shake, then maybe don't hold a piece of paper or kind of be in front of a podium so that the judge won't be able to see. And I think pace is always very difficult and people will naturally find themselves speeding up. So if you think you're going too slow, trust me, you can go slower. So always try to just take a deep breath, slow down, even if you think you're already speaking really slowly. The judge will appreciate you speaking really slowly. And what I like to do in my speech is I usually write the number of minutes in like the page of my speech where I should be at when I've timed it, when I'm practicing. So I know that if I get to a part of my speech that says 7 minutes and I'm only at 5 minutes, then I know that I've been speaking way too fast and I really should just slow down for the rest of it. Also important is to watch the judge. When we're judging, we're usually looking off to the side of the screen or making notes, so looking down. And if we're kind of looking down or not looking at you, it indicates that we're trying to make notes or trying to find a piece of information that you've directed us to. And maybe you need to take a second so the judge can finish what they're writing or finish what they're looking for and actually come back to you and maybe nod for you to continue your speech. There's no point in you delivering your presentation if the judge seems confused or isn't following what you're saying. All your kind of good arguments will be lost because the judge isn't following what you're saying. You have to remember that it's a conversation with the judge, so you can't just deliver it like a debate. You're not speaking to an audience, you're speaking to the judge, and if they're not paying attention, then you're not communicating effectively.
That without doubt is one of the most difficult things to get to grips with, because it's so normal, especially the first times. You're going to be nervous. You've got the, let's call it the comfort blanket of your notes in front of you, and you know you want to get across all information that you've diligently prepared. But the focus of attention has to be on your words and on the judge understanding and listening to those words. So as Kelsey says, if the judge is busy making notes, don't go charging on ahead. It's so important. The judge is first of all, will not be able to finish his or her notes. Secondly, will not be able to sort of grasp what you're now saying. And thirdly, will just get annoyed because you think, why are you not respecting me? That I'm trying to sort of note down what you've said, and you've gone blasting off ahead. So you must engage, and it does take a sort of a bit of sang-froid to realize, okay, it's okay. The judge is making notes. I can just pause for a second. That's how you come across as confident. That's how you come across as engaging with, working with the judge. As Kelsey has said, it's a conversation, but one where the judge is in charge. Okay, and you must always remember that. Kelsey, back to you.
Okay, so the next ones are about kind of points made are about tone and emphasizing certain words. So you do have 7 minutes to make your submission, but if you're giving a monotone submission or only delivering it at one pace, even if you could be kind of picking up a very forceful tone or sort of very persuasive tone, if you have that throughout the whole submission, it will be very difficult for the judge to tell where your important arguments are. So it's important for you to be able to tailor your tone, your emphasis to which ones are important. You want to pick a very neutral tone for things like, if it pleases the court, I will move on to my second submission, or if I could direct your lordship to the page 3 of the bundle. But you want to really emphasize using your tone and using your choice of language about which of your arguments are the strongest and which are the ones that you want the judge to pay attention to. And putting in keywords can be really helpful here, just to bring the judge and key him back in to the kind of conversation that we're having, so that they can then make a note of that important point. And make it clear when you're introducing a new point, rebutting or concluding. This will help the judge understand where you are in your argument. It's very easy as a judge to get a bit confused when someone is in their submission and then start bringing in things that sound like they're talking about the other side. And it might be that you are making a rebuttal point, but it doesn't always come across to the judge that way without you explicitly saying, I would like to rebut points made by the other side. And this is important. So your speech that you write shouldn't be like an essay. It shouldn't read well. It should be able to be delivered well. And that's the kind of key difference that you've got to make sure that you pick up in terms of presentation. And it can be quite difficult. So yeah, I recommend reading your speech to a friend and making sure that they understand what you're saying without actually having looked at a piece of paper. And then there's just some things about body language. So if you can, try and keep eye contact with the judge. This is difficult through a computer, obviously, but the important thing is that if you have a piece of paper, you're not just looking at the piece of paper. You want to make sure that you're every so often just making eye contact with the judge, making sure you know, are they looking down? Are they making notes? Are they making eye contact with me? Fidgeting excessively may distract the judge from the argument you're making. We have had some people chewing gum in some competitions. I won't name any names. That Peter was not happy with that. So don't do anything like that. Don't click your pen. Don't kind of toss a water bottle around. Nothing like that. Just try and be as still as possible. I promise it will help you. When in person, counsel should not stray around the room. Kind of the same thing in video. Don't sort of be moving around. If you're on a spinning chair, don't spin. Just things like that. Try and just keep yourself as kind of still as possible so that the judge is only focusing on what you're saying and how you're saying it. Think about how you may present yourself to appear as confident and prepared to the judge. So standing straight, having notes neatly placed, and ensuring that you look neat, which is a bit of a weird phrasing, but I assume most of you will be taking part in the competition while you're at school. So just, if you've got a robe, you can wear a robe. Just make sure you're coming across to the judge as professional and confident.
So what one suggestion, maybe have a sort of background, so we don't want to see sort of people randomly walking around behind you, because that also can be quite distracting. And in terms of one sort of trap that it's very, very easy to fall into. Now, if I'm looking like this, it might seem as if, goodness me, what's he doing? Why is he not looking at me? Well, I am actually looking at Kelsey and at Libby right now, and the great presentation, but it's on my big screen. But for me to actually make eye contact, I have to look down at my small laptop. So just think about that if you're using sort of multiple screens. I've got 3 screens in front of me, and I can look at one, and I think well, it's much easier for me to read the big screen, but I'm not making the eye contact. So it's really, really important to make sure you're looking straight into that small little white dot that is the camera on your laptop.
So the next couple of slides are mostly going to cover judicial etiquette specifically, and that's a really important part of your moot and a great way to get across to your judge that you're speaking formally. So firstly, just covering how you're going to address the judge. So you always have to refer to the judge as either my lord or my lady, or your lordship or your ladyship. And we spoke a little bit last week about the situations where you'd use those. So if you're going to say you, it would be your ladyship or your lordship. So you'd say, if I could direct your ladyship to page 6 of the judgment pack, for example. And then if you're wanting to emphasize a point in your speech, that's best you saying my lord or my lady. So you'd say, my lord, the submission of the appellants relates to so-and-so. And if you're not sure about how to address the judge, you can always, just before you start your moot, just ask, because then at least you know that you've got it correct. And it's always best if you can, if you're going to make flashcards or a speech, to write down my L or your L-ship. And that way you've not written down my lady and you say that by accident as you're reading your speech, and it just makes sure that you're able to adjust to whichever judges you have. So this is in relation specifically to the junior appellant, but it's their job to. Also, we've got a question in the Q&A here, just about whether you can engage the judge in a conversation, and I think that's firstly a great question, and secondly, the main purpose of a moot is for a judge to be able to have a conversation with you about the legal point that you're making. So when the judge asks you a question, I know that it's really tempting to just get your answer out as quick as possible and just go back to what part of your speech that you're at, and just resume the part that you've prepared. But the judges will always be really impressed if you're able to consider their question carefully and actually answer their question and open up that conversation with them, because a moot is meant to be a legal conversation, and so you'll get the most marks by actually answering the judge's question and being able to go off of the script that you've written and answer kind of off the top of your head. So the junior appellant will introduce the court and offer facts of the case. And when you're introducing the court, that should be yourself, your senior counsel, so your partner, and then also your learned friend. So that would be the opposing counsel that you have in your moot. So you're wanting to give your title and your name. So instead of just saying my name, which is Ria Mehta, it would be, for example, Miss Ria Mehta. And if you're not sure of everyone's names, again, at the start of the moot, see if you would be asking about the title to refer to your judge. You could also just stop at the start of the moot and just say, can I just make sure I have everybody's names correct? And I'm not sure if that's something that will be sent out ahead of time, but you could always just ask at the start of your moot if you're unsure as well. And also, if you can briefly explain what your grounds are and the specific ground that you'll be submitting as well, that will give a really clear idea to the judge of what it is that you will be submitting and what it is that your partner will be submitting. And it outlines your argument so that they've got a roadmap and they will be more aware of your structure and your main points. And that will get you really great marks as well.
Ria, if I could just add something before we move on to the next slide about kind of engaging the judge in a conversation. Essentially, you will be leading the conversation by giving your submission, and then the judge will be asking you questions, and you are expected, as Ria said, to answer those particular questions that they set. And I just want to make it clear that your job isn't to ask the judge questions. So please don't make sure you do that. You're able to check if they have sight and things like that. But I've had moots where I think it was they started asking me like where I would like them to go in their submission, and if you're giving a judge that much leeway, then they're just going to be difficult and pick the worst thing. So I think I made them jump to the last submission, but for no reason. So just an important point to make: you're expected to answer questions put by the judge, but you shouldn't really be asking the judge questions about substantial points of law.
So finally, just another point about introducing a case. So case citations will appear differently written as they are to be said. So for example, if you're looking at the case citation there, that says Donahue v. Stevenson, but you wouldn't actually say the V. The V would translate to an and instead. So it'd be Donahue and Stevenson. And then if you were going to say the citation, which usually is the year in brackets and then an acronym and a number. So instead you'd say that as heard in 1932, you'd say the court, which is the House of Lords, reported in the appeal cases, and beginning on page 562. And that's a great way to show to the judge that you can break down a citation and that you are able to give the correct court for that situation. And then after that, when you're directing the judge to your judgment pack, if you follow their cues, that will usually help you during your moot. So usually a judge will either nod or smile at you if they found the page. And if you're watching the judge closely and they haven't kind of nodded at you, then you could prompt them and say, does your lordship have sight? But it's always good to just check first, because if they're following your argument, it'd be a good way for you to show that you're paying attention to your judge's cues. And then finally, you're wanting to offer the facts of the case to the judge. They might ask you if they're relevant to your argument, or they might say, yes, I'd like to hear them very briefly, or that they are already familiar with the case. And if they say that they're already familiar, then they're not wanting the facts. But for the other two, you can then give them a brief summary of the facts of the case. I always like to have that in kind of a bullet point or two, just in case they're wanting the facts for any of the cases that I have in my speech. And then once you have offered the facts and given those, if the judge is wanting them, you can direct the judge to the page in the judgment pack that you'll be quoting. And when you start your quote, you should give the name of the judge that you'll be quoting and then read that quote out that's on the page.
So when you are concluding your submissions, your job is essentially to summarize your argument to the judge before you. So usually this is the role of the senior counsel. So as a senior counsel, it is your job to conclude for your side. So not only for your own submissions, but for your junior counsel. Now make sure that when you are concluding your submissions, that it is strong and it again summarizes and illustrates all of the arguments you have put forward. Now, at the very end of your submission, don't just sit down and kind of run away from judicial intervention. You know, we love it when you ask us what you would like to do. So sometimes it would be like, if the court has no further questions, we will ask the court to dismiss the appeal. Or you can even say, as mentioned, that you will conclude your submission. And usually the judge, if we have questions, we will very quickly unmute and ask you the question. And if not, once you've realized that we have no more questions and we kind of give you a nod, then please do, sit down. Now, in terms of the time limit, as Kelsey reminded us at the beginning of the lecture, it is 7 minutes. So Libby will be holding a sign with, 2 minutes. There we are. You've got the sign. So 2 minutes, it means that you have 2 minutes left to submit. 1 minute, you've got 1 minute left. And time means that essentially your 7 minutes has run out. And thus you should kind of finish your submission, and you should not kind of expect us to let you go over. So make sure when you are writing your speech that you've left a bit of time left. We'll be speaking about this a bit more in the next slide. And as Kelsey mentioned, you need to kind of balance between not speaking too quickly, but not too slowly. So finding that balance is essentially crucial. And that's why we recommend for you to practice by timing it and going over your speech with your friends and so on. So the other tips that we have in terms of keeping within the time limit. So firstly, it's very important that judicial intervention will be included in the time. As I've just mentioned, it is recommended to leave just a bit of time. So technically your speech should run for 6 minutes or 5.5, depending on your pace, so that when we do ask you questions, you will still have enough time to conclude and kind of give us all of your arguments that you've prepared. Secondly, we would recommend to include only relevant authorities. And what we mean by relevant is that preferably you should prioritize binding cases, as the time limit is very tight. Lastly, you should also be very concise when you're providing the facts of the case. Now, it's very easy to just explain the facts and talk about the case for 7 minutes. And that is not what we want you to do. We are looking for your analysis and your interpretation of the law. So ideally, do not go on too long about the facts. And if you think that it's not relevant to the argument, you can instead say, my lord or my lady, I do not believe the facts are relevant to this case. If my lady allows, I would like to direct you to page 7 of the judgment pact. So you can kind of, limit wasting your time on irrelevant facts. And as highlighted and capitalized, do not assume that we will let you go over the time limit. Ideally, once the time is up, do stop. Do not even try to continue and rush your final sentence. We will stop you there, and essentially we'll stop listening after 7 minutes.
So I just say I will normally allow for a couple of seconds to finish a sentence, but then I will also verbally, when I put up a card to say your time is up, but then I will also verbally say your time is up, thank you. So.
Hi everyone again. I'll talk a little bit about judicial intervention. In my personal opinion, that's the most stressful part. So we already discussed that before. So judicial intervention is essentially when judge interrupts you and asks you questions. They're not trying to argue with you. Please don't try to argue with the judge. That's very important. You're just there to answer the question. And they just simply want to know, how well do you know your argument? How well do you know your cases? And whether you can think on your feet and respond to the question quickly, come up with the right answer. So when you are answering the judge's question, try to keep your pace slow and try to use formal language. So usually you will have your speech written down, and that would be using formal English. So try to maintain using formal English and not switch to just a regular informal language and like slang. If you don't understand the question, it's absolutely okay to ask to repeat the question or to rephrase the question. And if you're really struggling with something, you can ask to consult with your senior or junior. I think it's also important to note that you don't have a lot of time, and consulting with your partner might take some time. So think about that in advance. And I think it's a good idea to prepare for some questions. Some of them you cannot prepare for them about your substantial part of your submission, about what you're talking about. You don't really know what judge will ask you. But you can also prepare for the questions about the quotes. In my mooting experience, judges really like to ask you about what court the case was heard in. So always write down in your submission what is the court of the case, and think about whether it's binding or persuasive. So if we are in a court of appeal and you are citing a decision of Supreme Court, this decision is binding. If not, the decision can be just persuasive, or if you're using decision of the case in another country, for example, that's just simply persuasive. So I think there is a great chance that the judges will ask you something about the quote, so just be prepared for that. And also, sometimes you might think that the questions that the judge is asking, you will cover it later in your submission. I definitely did that, but it's not a good idea to say, my lord, I will cover it later. It's better to just answer the question there and then right away, and yeah, just don't make them wait. Thank you. And now a little bit about rebuttal. This is when you are expected to respond to submission of your opponents. So it's better to make a rebuttal. Each mooter is, in best case scenario, expected to make one. You will be preparing for both sides of the argument. So I think coming up with like grounds for your rebuttal shouldn't be very difficult, because you're already prepared for both appellant and respondent. And what you are trying to achieve in your rebuttal is if there are conflicting authorities and there are conflicting arguments, you're just trying to persuade the judge that your interpretation of law in this particular case is the better one and the right one. To show the teamwork, I think it's a good idea to sit together with your mooting partner, discuss what can be points of rebuttal and just split them. Another way of doing that is when your junior, for example, starts on one particular part of the rebuttal, and then you, for example, as a senior, continue that saying, as was mentioned by my learned friend or my junior, and then you continue the same line of argument. I think that's a really good way to show teamwork. And an example of the language that you might be using is, my learned friends across the bar have argued that, and they are made some point that they're making, and in response to this, it is submitted, and you're persuading the judge that your interpretation of law is the right one. Also, I'm not sure if we mentioned that, but there is no objection in the moot. I was a little bit surprised when I started internal competitions. I thought, oh wow, now it's the time, scream objections. But I think rebuttal is kind of a good substitute for objection, because you're objecting to the what argument your other side, your opponents are making, but in a more respectful way. Yeah, and it also possible that the judge might ask you questions about the your opponent's arguments in the moment. So just pay attention to what your opposing counsels are saying. And to cover some key terminology again, we've talked about what the moot is. Talking about authorities, I think back to what Hannah was saying, just make sure you're using primary authorities, not just books, but rather cases and legislation. And also make sure that the cases you're using are binding. So the stronger the case is, the better. Rebuttal is when you're trying to show the judge that the argument you're making is the better one. I think about rebuttal, it's worth mentioning that you don't have a lot of time and you shouldn't be spending too much time on your rebuttal. And also make it a powerful argument. So don't just pick on something your opposing counsels might say, something completely irrelevant or something very minor. Maybe try your best to find the main point of their argument and just show the judge that the point you are making is better. Then counsels are lawyers or barristers acting in the moot. Judicial interventions are the questions that are asked by the judge. Bundle, you will not have to make a bundle for this competition. You will have a judgment pack. So make sure that you are giving judges the pages of the judgment pack, and just make sure that you know what page it is on. So, but it's a good thing that you don't have to make your own one, because it's sometimes a little bit time consuming. So appellants and respondents are the two sides in a moot. Appealing party is the one that argues that the decision should be overturned, and the respondents that are arguing that the previous decision that was made was the correct one. Judge's first instance is the first judge that hears the case and made an initial decision, and the submission is the speech that you are making. So yeah, if there are any questions, please do ask them. Just double check if there's anything. No.
Okay, so I'm not sure how long we'll wait about questions, but I'll stop screen sharing so we can all be here. But yeah, we're happy to answer anything about questions that anyone has about this particular lecture or any of the kind of the previous lectures we've delivered over the past few weeks.
Can I just ask a question to start the ball rolling? So when you are making a rebuttal and you want to demonstrate that your reading of the case, or your argument is more persuasive, you believe, than your opponent's. How do you do that? What do you do? What do you use in order to do that? Who's going to answer?
Yeah, I think I will. So as for this competition, the guys will be preparing for both sides, I think, for appellants and respondents. I don't think it should be very difficult because you're already prepared to make an argument for both. So basically, when you're doing a rebuttal, you're just saying that what you prepared for this side, you're just trying to make it look weaker. So you're researching both sides of the case, and I think it comes naturally. But yeah, if you guys have anything to add.
Yeah, it's kind of a lot of the moots that we do, the legal problems will be quite a lot of them will be quite contentious, and a lot of times it comes down to kind of a tiny point of law, which could really go either way, and that's kind of the main crux. So as you'll see in the internal competition, the whole point of the parties appealing is whether or not the postal rule should apply. So you're going to have, for the appellant, a set of arguments for why it should apply, and for the respondent, a set of arguments for why it shouldn't apply. And those arguments won't be exactly equal to one another, but some will be stronger than the others are. Some will be relying on authorities that are not binding. Some will be. So it's just, you know what I mean? You have to think of it as like 50-50 or like a seesaw. You just want to tip the judge slightly in your favor in order to kind of demonstrate that rebuttal. And we're not looking for something crazy. Do you know what I mean? We're just expecting you to make an argument that makes sense about why one argument is potentially better than another, based on a specific set of facts. So it could be anything. I don't think there's a wrong way exactly to do a rebuttal. I think we had someone with their hand up, or is Ria going to answer a question?
Yes, there's a question from Wemma. I was going to ask Wemma if she'd like to, or if they would like to unmute themselves and ask the question in person. You're very welcome to.
Thank you. Yes, I wanted to ask, when making a rebuttal, one of the slides said that it's a good way to show teamwork. So how are you able to convince the judge that you've shown teamwork through your response? Yeah, through your rebuttal.
Yeah. So it's a great question to ask, especially because it's one of the criteria that we're marking on. So the two things that I do personally, which always really help towards the teamwork score, is I always have like a notebook in front of me, and it'll be something I'm able to show my partner while we're doing our moot. So that if something comes to mind that the opponents have said that you're wanting to comment on or add into your speech, you can show that to your partner. And while you're doing that, the judges will be seeing that you are both communicating. And another great way as well is to try and have some part of your speech, even if it's just one line, that references your senior or your junior's argument. So it shows that you guys have prepared together, and that your argument, or even part of your rebuttal, could link to both parts of your argument, just so that it's showing the judge that there's some coordination between the both of you.
Yeah, just to kind of build on what Ria said, if you're the junior appellant, you won't have any chance to rebut any arguments because you'll be going first and you won't have heard any of the submissions. So if you're the senior appellant, and the junior respondent made an argument that contradicted your junior's argument, then it's a great way for you to say, I understand my junior's arguments, I will rebut what they've said based on that argument. So that's kind of a little bit how it's built in. But in general, for teamwork, I think it's only scored out of 5. Correct me if I'm wrong, for teamwork. So it is a smaller score compared to some of the other criteria. But basically, the things that we're looking for is, have you balanced your two arguments well? Are you repeating anything that each other's saying? And if you are, get rid of it. Do you know what I mean? Because one of you is going to cover one point, one of you is going to cover the other. Have you introduced both arguments well? Have you concluded both arguments well? It might be that the judge asked you a question that your senior is going to cover. So you can either say, thank you for the question, my lord. While this relates to the argument of the appellants, it will be discussed by the senior appellant. However, it would be really good if you actually knew the answer, and the judge won't ask you a horrible question about the other side, about your partner's argument. But if you've not introduced who'll be dealing with what in your introduction, then it could be a bit confusing for the judge and he might not know who's talking about what. So that's potentially a way to get like a really good mark is if you know their argument inside and out.
That idea of really, really good coordination and integration is really essential to teamwork. So it's we in terms of things that are visible, you might see if somebody passes a note from one person to the other, but that's not going to happen that often. It is really the teamwork is taking place in advance, that really coordinating and disciplined approach to making sure that each member of the team knows what her or his role is, and they execute it appropriately. Any other questions people like to ask? I see some of the teachers are here. If they want to ask questions, please feel free to do so. It is going to mean that I'm going to ask a question, and then the team's not going to like this. So, Kelsey, you've been involved in mooting for quite a number of years, in training sort of mooters at Dundee and judging lots of moots in this competition and in internal Dundee competition. But when people are mooting for the first time, what are the most obvious mistakes that they make in terms of oral presentation?
I think it's really clear, as I think Rihanna spoke about it, was the fact is they could be so polite and professional while they're reading their speech, but as soon as you ask them a question, all the formalities just get pushed to the side. And it's a shame because you could have been doing really well, but as soon as you get asked a question, you just absolutely kind of lose character. And what we're really looking for is consistency. So if you can be consistently formal throughout the whole thing, I guarantee that you'll score pretty highly. And that's the case of, don't rush in with your first answer when the judge asks you a question. Really take a second and think, I need to remember to say my lord or my lady. I need to remember to not use jargon or slang or something like that, and that you deliver an answer that's quite coherent. And really don't be afraid to just take a second and think about it. A small pause with you thinking is not going to come across as very long to the judge. But I've had some cases where I think, I'm trying to remember, people have definitely said cool to me in a moot speech. So they'll ask.
That's not cool.
No, I was like, oh, please no. Because they'll ask me if I wanted to know the facts of a case, and I'll be like, thank you, counsel, I'm already familiar with the facts of the case, and they won't know what to say in their head. So the first thing that comes out is cool. And in those instances, please, saying nothing is better than saying something like cool. So
my lady, I'm obliged.
Yeah, I'm obliged, or thank you, my lady, something like that, or just say nothing and give a brief nod. I promise if you don't respond to something like that, it's totally fine. That isn't something that needs an answer.
Cool.
So just try not to say cool, and we'll be fine.
So maybe don't have your white holiday cup right beside, but a glass of water in a nice sort of standard size glass, and have a little sip of that. That will help you sort of gain your composure. And as Kelsey says, it's so important not to rush in. That certainly for me is a mistake that I've seen so often. And in terms of practicing beforehand, you've got to practice asking each other questions, and asking questions in the way that a judge would ask, but sort of stopping somebody almost mid-flow. Miss Laird, if I can just interrupt you a second, can you explain, ask for an issue or that case to which you refer, is that binding on the court today? So you need to get the habit that you will be stopped. We're not going to wait for a natural pause. I'm not necessarily going to wait for a natural pause in your flow. So you've got to be prepared to react to that. And as Kelsey said, to keep your composure and cool, not to say inappropriate things. So, Libby, do we have any other questions?
I can't see any further questions. I can't see any further questions, so I think we're good.
Brilliant.
A quick reminder from me, please, to get in touch as soon as possible with as many available times over the coming 2 weeks. So obviously we have limited availability here within the team. So if you can give us as many times as possible, then we are more likely to be able to give you one of those times which suits you best.
Brilliant. Well, thanks very much, everybody, for tuning in. Oh, we do have a hand. I saw a hand went up momentarily.
I don't see one.
I think it was Mary
Yambongo. Is that a mistake, Mary? You see, we're sort of looking here for these hands to go up. There's no escape if you make a mistake. Give me a chance, Mary. Do you want to ask a question?
No,
Mary.
it was a mistake. It was a mistake.
Oh, it was a mistake. Okay. No problem at all. Well, thank you so much, everybody, for either joining in live and to those of you watching.
We do have one question. Can the judge, so here we go, can the judge ask questions at any time? If he or she can, if you ask to refer to your colleagues, will that affect your time maybe during your speech? Yes.
So the questions, the clock does not stop with the questions. So that is also something really, really important to factor in when you're working out what you're going to say. So you can't predict which question you're going to be asked. And we don't have a list of, well, it'll often come to our minds when we're listening to the presentation as to a question to ask. And it may be a simple question, or it may be a question that requires a bit more explanation. And if that takes a minute and a half for you to think, to compose yourself and to give your answer, you're not going to get that minute and a half at the end to sort of finish off the stuff you're going to say. So you need to be flexible. Flexibility is so important when you're presenting a case in court. It's so important in mooting. So you need to be able to have information that you'll give if you're not asked detailed questions, and information that you know that you have to give because it is central for you to make your course submissions. So you need to be able to factor that in and have that flexibility.
And Mary, you do have your hand up now, so.
Yeah. Would the judges tell us what we're supposed to talk about? Like beforehand, would they tell us what we're supposed to, what our 7-minute talk should be about?
Yes.
Okay, so yeah. So we've sent the internal problem. So the problem that we're going to be looking at over the next 2 weeks in the workshop, and the problem that you will compete about first, which will be in January, has already been sent on to the schools alongside the judgment pack. So that is a moot problem that has been devised. All of the judgments have been pulled together for you. And next week, the team will be going over legal issues relating to that moot problem. And then your workshops will also, there'll be one workshop where you'll be looking at developing your argument as counsel for the appellant. And then the second workshop will be as counsel for the respondent. So you will have some help and guidance, but you will all be looking at the same problem, and you'll be competing within schools in January, and then in March you'll be given. We'll circulate another problem next semester, and there'll be a couple of sessions on the problem that you'll be arguing on in the Pan-African competition. So that will be against other schools, most likely from different countries as well. Does that kind of explain?
Yes, thank you, my lady.
We've just got another question. I'll just read it out. Is it better if we answer the judge's question in detail and lose some time for more points we previously had, or would it be okay to prioritize the points we have and just briefly answer the judge's question? I don't think you want to be too brief in how you answer the question. A common question that we will ask is this case binding? And a lot of the time people will say yes or no. And while that is correct, we as judges are expecting a bit more than that. We want a detailed answer of, yes, my lord, it is binding because it was heard in this court. If not, we will ask you follow-up questions, which might actually take more time trying to actually pull a full answer out of you. And I don't think if you answer a question really, really well, we're not going to, say if it takes you a minute, we're not going to kind of deduct marks from you not finishing on time because you gave us a really good answer. So it's hard. It's not that we kind of pick at it that much, but if you have a really good answer to a question, by all means say it. Like it's just going to get the judge, you're actually engaging in the conversation with the judge, and that's what we want. So I'd always say, if you know the answer to the question and you think you can give a really solid and confident answer, do it. And that might mean you have to rejig your speech a bit or leave out some points, but that's fine because you came across well in your judicial intervention.
Try not to look too shocked when you're asked the question. So the lower jaw dropping is not a good look. And the panicked looking to either side of you, say, oh my God, please somebody give me the answer. That's also not a good look. But as a teammate, and this goes back to the issue of teamwork, if your teammates ask the question and you immediately know the answer, don't just sit there going, is he going to know the answer to that? Immediately put the answer down on a piece of paper in legible writing so you can show it to your teammate, and then either they can get the answer or it's reaffirmed for them. But during that time, the counsel who's speaking, who's being questioned, she or he is maintaining their composure, their dignity, and not looking shocked.
And we've got another question just about timing. So yes, you do have a time limit. Your time limit is 7 minutes. So you'll be given 7 minutes. I will time every submission, and I will start the timer as soon as you start speaking. You'll be given a 2-minute warning, which will be a visual warning, a 1-minute warning, which will also be a visual warning. And I will also tell you and show you when your time is up.
And we just stop you.
Yes. Fantastic.
Brilliant. Well, that's great. Thanks very much. Another fantastic session. I'm so glad to be back for this one, and I will see you all, the rest of the team, and Libby next Wednesday again when we're doing the legal issues, which is a big one. So definitely, if you're watching the recording, do try and tune in live next Wednesday afternoon at 3 o'clock UK time. 3 o'clock UK time next week, which may be a different time depending on where you are in Africa. We will be in the same time as Ghana next week, but we will not be in the same time as Nigeria anymore because the clocks change in the UK this coming weekend. So just remember that. Okay, so thanks very much, everybody. Goodbye from Dundee, and see you all next week.
Thank you. Bye.
Bye.